Privacy Forum. We are a global nonprofit organization specializing in privacy and data protection law and policy, with a particular focus on commercial regulation of emerging technology. My name is Stacey Gray. I'm a senior director at FPF's recently launched Center for Artificial Intelligence. And I'm joined by three incredible speakers today. Given future privacy forums focus, you might be surprised that we're talking today about the Privacy Act, because as you're going to hear more about in a few minutes, the Privacy Act is the primary federal law in the United States that relates to the public sector, specifically governing federal agencies and certain federal contractors' use and disclosure of personal information in systems of records. There are a couple of reasons for this. The first is that the lines between government and commercial use are increasingly blurring. And the second is that we're celebrating a significant milestone anniversary today. Exactly 50 years ago today, on November 21st, 1974, the United States Senate passed Senate Bill 3418, as reported by the Committee on Government Operations, which is now known as the Homeland Security and Government Affairs Committee. This landmark piece of legislation would go on to pass both chambers of commerce and was signed into law by President Ford at the very end of 1974. So we're going to get more into that. We're going to kind of talk a little bit about the past, the present, and the future of the Privacy Act in commemoration of this anniversary. We've assembled three distinguished speakers today who are going to help me explore the historical significance of this legislation, and let me briefly introduce them. We have first Mr. Bob Gellman, a renowned privacy and information policy consultant with over 4 decades of experience. Mr. Gellman's widely recognized as one of the foremost experts on federal information policy that exists. And I'm also hoping that when I turn things over to him in just a moment, he'll tell you more about his specific experience working on the Privacy Act. Next, we have Ms. Pam Dixon. Pam is the founder and executive director of the World Privacy Forum, a respected public interest research group. And lastly, Mr. Peter Winn from the Department of Justice, who brings a critical government perspective to this discussion. Mr. Winn is the acting Chief Privacy and Civil Liberties Officer of the United States Department of Justice. So over the next hour, we're going to talk about the Privacy Act, its origin, its ongoing relevance in an era of unprecedented information sharing, and the challenges of protecting individual privacy in a complex technology landscape. Looking forward to a robust and excellent discussion. We're gonna kick it right off. For those who are listening and joining us here today, I should say that we do have a Q&A feature. We're going to have an open period at the end of this discussion, at the end of the hour, for Q&A. But I also welcome you to put questions in throughout the discussion, and I will bring them into the conversation as it's relevant. You can post, I believe you can post anonymously, or you can post as yourself. Please send us questions throughout, and we'll have an excellent discussion. So before we talk about how effective the Privacy Act has been, or how effective it hasn't been, let's ground this topic in some history. At a high level, Pam, I'm going to turn first to you. Tell us more about the Privacy Act. What is it? Why did it come about at the time that it did? Lawmakers in the early 1970s had a range of fears and concerns and motivations. What were they?
Okay, so, well, first off, thanks for your invitation. And just for anyone who's watching this, I'm at OECD right now. I couldn't get back to my hotel room to get away from this background. So very sorry. But I hope you don't mind. I'm going to ignore your question. So I want to talk with you about the first time I ever worked with Bob Gellman on a Privacy Act issue. It was right when I founded World Privacy Forum. This was actually before you guys were even founded. And it was in early 2000s. It was like 2002. And we were working on a report. It was the first report we did. It was about a job site that was selling resumes. And I'm like, can you help me figure out if there was a system of records? He's like, oh, yeah, this is great. So he wrote this massive thing about routine uses and all sorts of really obscure Privacy Act references. And lo and behold, a couple of weeks later, I get this phone call from this guy. And he said, are you Pam Dixon? I said, yeah. He goes, do you know Bob Gellman? And it was because, and then he goes, you know, Bob's the only person who could have written this letter. That's the only reason I asked. And then we had a very long session and we eventually got the report out. But anyhow, if you're going to write a Privacy Act letter to the government, the main person you ever want to talk to is Bob Gellman. So I'm going to pass it off to Bob. And there was a certain question that's been floated about whether the Privacy Act ever applied to commercial entities. And I'm going to let you deliver that big answer there, and I'm going to just wait.
Thank you for inviting me to this. I got my start in privacy when the Privacy Act passed, and it was 1975, and I was working at an agency that claimed not to be subject to the Privacy Act and still does make that claim. And I was assigned to be the Privacy Act lawyer for the agency. I later went on to Capitol Hill. I worked in the House for 17 years, and among lots of other things, I was the chief staffer for the Privacy Act for that whole time. So I was not involved in the passage of the act, but when it first came up, the Senate bill covered the private sector. It was not a very thoughtful or well put together bill, typical for the Senate. That you can chalk that up to House Senate staff rivalries. What happened in the end was the House passed a much narrower bill, and it went to conference, or what was a form of a conference right at the end of the Congress in a lame duck session. And the rules there were no rules that applied, and the House Republicans said, we're only willing to support so many things, and a lot of issues that were raised in the Senate bill were just dumped. There was no time, and the narrow House bill passed. Instead of covering the private sector, they included a provision that established the Privacy Protection Study Commission, which issued a report 3 years later. And that was the commercial connection to the Privacy Act of 1974, which no longer exists.
I love this particular piece of trivia because I think there are those at FPF who like to think of it as the United States' missed opportunity to have an early version of something that later influenced data protection laws around the world, kind of a US GDPR as far back as 1974, which then, of course, ended up not happening. And now the law applies only to federal agency and certain contractors. Bob, can we why don't we continue on this thread for just a moment and talk a little bit about the motivations, the problems that the original act, as it passed, related to the federal government, were trying to solve, like the motivations there?
Well, the origins of the law come actually from what was then the Department of Health, Education, and Welfare, and there was an advisory committee set up by Elliot Richardson, who was then the secretary, and the advisory committee, among other things, its most notable contribution was the proposal of fair information practices. And the first version of fair information practices came from the committee. And the committee also recommended legislation which largely tracks what the Congress ultimately adopted a few years later. And that's sort of where it all came from. And the focus of that committee was relatively narrow. Peter knows a lot more about the history of the committee than I do.
Yeah, so I just wanted to highlight what Bob emphasized about the committee. It was set up by Elliot Richardson, who at the time was the secretary of HEW. By the time the report came out in July of 1973, Richardson was now the Attorney General of the United States. And what's very significant about this report, and Bob's showing it, Records, Computers, and the Rights of Citizens, is it actually not only developed, really for the first time, a comprehensive idea of these fair information practices. If you collect information from someone, you ought to make sure they know why you're collecting it. You should only use it for the purposes that are compatible with the purposes that you collected it for. If you use it for something that's incompatible with those purposes, you ought to get their permission. They ought to be able to access the information, make sure it's accurate. If it's not accurate, then you ought to have to fix it, correct it, make sure it's accurate. And there ought to be some means to hold the agencies, the institutions accountable if they don't follow those principles. But what Richardson and the original committee that enacted the Fair Information Practices, the book that Bob shows, if you read that book, and I would strongly encourage everyone to do so, it's on my office's website, so you can see it there. It's, you know, if you don't want to have to pay for it, is that it carves out law enforcement and national security activities. And the reason for this is simple, because if you look at how they described the nature of privacy, they described the privacy type interest that the Fair Information Practices applied to, in their words, as being a fundamentally mutual interest in the use of the information. That is a shared interest. The institution and the individual, when they have relationships of mutuality, they have the same interests in that information. That it's just as much in the interest of, say, the Medicare agencies, that the information be accurate and that the beneficiaries of the Medicare program know what they're collecting and why they're collecting it and only use it for the purposes it's collected for. That's just as much in the interest of the individual as the institution, the agency. What that's not characteristic of is, say, the relationship between the CIA and Osama bin Laden, or the relationship between a law enforcement agency and someone like Al Capone. That the relationship when you're investigating a gangster or a terrorist is not one you'd generally describe as of a mutual interest in the use of the information. It's adversarial. And so, you know, Al Capone can't go into the Treasury. Now it's the Department of Justice, but the people who are investigating him for gangster, you know, being a gangster, a bootlegger, and say, hey, you know, this, I'm shocked that you accuse me of this. Fix my records. The investigations are inherently secret, where one of the things that the committee emphasized is the importance of transparency in connection with these relationships of mutuality. And so Richardson, recognizing this, brought the team over to the Department of Justice. This is a little known, and got them working on filling the gap for law enforcement and national security. You know, how do you maintain trust in connection with law enforcement and national security activities? Unfortunately, the Saturday Night Massacre happened in October of 1973, and Richardson was fired. This had to do with the Watergate scandal. He refused to fire Archibald Cox, who was trying to get the Watergate tapes. And the group of people who were working on this, Willis Ware, David Martin, Carol Parsons, they were all basically sent home, and that was never completed, that filling in the gaps of the Fair Information Practices. And it really was only begun to, you know, that gap only really began to be completed, to be filled in 2022 with the OECD, where Pam is now, Trusted Government Access Principles for access to personal data in the private sector. And the OECD in 1980, with the support, participation of some of the same people who were involved in the creation of the 1973 report that Bob was talking about, developed the OECD 1980 Fair Information Practices, which were based on these same ideas. But even there, they carve out law enforcement and national security. So a lot of people don't realize that the Fair Information Practices are really designed to be applicable in certain types of contexts. But in other contexts, you may need other principles. And so that's an important thing to see in connection with the Privacy Act. Because if you look at the Privacy Act, which, as Bob said, largely does embody these concepts that you see in the HEW report, it has the challenge of how do you have a set of general principles apply where you have agencies that are engaged in a great deal of different kinds of missions. And the way it does this is very interesting, and I think it's uniquely characteristic of the Privacy Act, and in my opinion, the reason the Privacy Act has been as successful as it has been. And while we're always struggling with our compliance, it has a relatively high compliance rate compared to, say, the GDPR, which has an extremely low compliance rate. And the reason is, if you think about the concept of compatibility, is what's compatible for the Department of Justice will be different from what's compatible for the Department of Health and Human Services or the Department of Social Security. And each department, each agency has different missions. And the way in which those concepts of compatibility, a loose concept, are spelled out is what are called routine uses, which go through an administrative process to spell out what you can and you can't do with information, and in particular, when you can and when you can't disclose it to other people. And those are all controlled by these routine uses, which is a really important concept that makes the Privacy Act function so well in such a variety of different contexts. The other thing that I think is really characteristic of the Privacy Act and makes it successful is this concept that you don't see right away, but the idea of retrievability, that you're retrieving information, and the Act applies to information only when it's retrieved from a system of records. And the retrievability requires a unique identifier that you're using to find an individual's records, usually to make a decision about them. That actually constrains the scope of the Act, but it also makes it, you can implement it. You don't end up going into the path of madness trying to figure out what is and what isn't PII. So partly, to the extent that there's been gaps in the Privacy Act, for instance, that's a fairly narrow footprint. Most agencies have expanded the coverage of the things that need to be expanded, both with respect, both by using the E-Government Act of 2002, as well as using policy associated with FOIA, where they're not disclosing, for instance, information that's subject to FOIA's privacy exemptions, even though in theory they could. As a matter of policy, they don't. And so they've generally pushed the privacy non-disclosure obligations throughout all their systems of records and all their agency records. But they end up but those access and amendment rights, which actually raise special administrative problems, are limited to records and systems of records that people are going to be using to make decisions about other people, and records that really have the types of concerns that are associated with the remedies that provides for. So a lot of people have criticized the Privacy Act, but I would submit that the best measure of the success of an act, of a law, is whether people are actually doing what the law requires. And on that measure, the Privacy Act tends to score fairly high.
Can I pop in real fast? I just want to unpack some of what Peter said. So these are conversations that Peter and Bob and I have had for many years and many hours. Stacey, you talked about precedent in the, privacy law. We have it. The United States has that already. The Privacy Act has been profoundly influential, and its associated output, which was the Fair Information Practices, which, as we all know, grew into the OECD process, which has been since updated, which of course founded kind of the bedrock for the EU 9546, the first data privacy directive, which was then the Giovanni Buttarelli's foundation for the GDPR. Now, of course, we have a different set of situations in front of us, and privacy is changing again. Bob and I wrote about that in our risky analysis report of last year, that privacy is getting ready to take a new step. But I think that in terms of the Privacy Act, if you had to ask me and say, what's really important here? Peter touched on it in what I would call a Department of Justice way. I'm going to touch on it in a civil society kind of sort of way. So, one of the problems when I look at the Privacy Act is there's so many exceptions You just look at it and you're like, wait, just a minute. I believe that to this day, the CIA pretty much exempts it's everything because that's how they can get that done. Peter, you'll have to correct me if I'm wrong. So there's a lot of meaningful exemptions. But here's the thing, the Privacy Act covers a lot and you can get a lot done. The key principle is there's no secret systems. And that principle has really suffused through the American and the US, I would say, the US kind of mindset. We don't exactly want secrets. However, what Peter was really talking about when he's talking about mutuality, he's talking about the fact that the exceptions of the Privacy Act. And this happens in GDPR too. So the question is in the Privacy Act and in EU 9546 and in the GDPR and in so many pieces of legislation today, what do you do when the law doesn't cover something? There's a lot that's left out of GDPR that's actually somewhat similar to the Privacy Act. I would argue that the Privacy Act is a little stronger in certain ways. And Peter and Bob, you can talk about that. But something that Peter referred to is something called the TGA at the OECD. It's the Trusted Government Access Principles. This was a very challenging 2-year negotiation between the OECD and the law enforcement national security agencies of the OECD member countries. And civil society participated. I helped negotiate that and fought a lot of different things and lost a lot of battles, frankly, but won a few. But the thing is, what Peter's talking about is that at some point, there ends up having to be 2 separate ways of looking at how you manage the data. And we still have gaps around data. So for example, in GDPR, national statistical systems are largely exempted, but they have other laws that cover them. So we still have to look for ways of filling in the gaps that the Privacy Act leaves around national security and law enforcement, but it does cover a lot of other things. I'll stop talking here.
Just to follow up on what Pam was saying, the GDPR does not apply at all to law enforcement and national security systems. At least the Privacy Act covers them and allows exemptions to be made, but some exemptions can't be made. For instance, the non-disclosure provisions of the Privacy Act can't be exempted. And there are other provisions about the Privacy Act that can't be exempted involving the reliability, the timeliness, the completeness, and the accuracy of information. So there are a lot of different provisions of the Privacy Act that do apply in the law enforcement and national security context, which you don't see in the EU structures because the EU lacks competence over law enforcement and national security. Now, with respect to the trusted government access principles that we were talking about that were developed a couple of years ago, what's very interesting about those is how similar the principles are. Even though the laws of all the member states in Europe and all the other members of the OECD, those are, include Japan, Korea, Israel, Turkey, Colombia, Mexico, a lot of different countries with a lot of different legal systems. The principles and the laws that you see in those countries, making sure that the information is properly used only for those law enforcement and national security purposes and protect privacy is really characteristic of democracies throughout the developed world. And they don't characterize, for instance, authoritarian regimes. And we know that authoritarian regimes don't protect privacy, but we often forget that the reason democratic societies stay democratic is because they have strong privacy laws. And that gets back to the Privacy Act in this sense. Why did the Privacy Act get passed? And Bob talked about the legislative history. We can certainly look at the leadership of people in the Senate and the House. Yes, Bob, there was leadership in the Senate too. But the main reason was Watergate. The main reason were the scandals associated with the abuses of law enforcement and national security power. The COINTELPRO scandals, for instance. These scandals were just popping when the Privacy Act was being negotiated. And Congress wanted to make sure that the relationship between government and people in the United States, that relationship of trust, was protected. And when they looked over and they saw what the committee, the HEW committee, had come up with, they thought, well, that strikes us as a pretty good start. And so the Privacy Act actually has a lot of strong restrictions that also apply to law enforcement and national security. For instance, you can't start creating systems of records or collecting information about people based on their First Amendment beliefs. That's very strong. And that's precisely the kind of thing that you see in the OECD Trusted Government Access Principles, which is it's all democracies have rules that prevent governments from spying on the people who are trying to get their jobs. Because for that, if that were allowed, it would be an existential threat to the democracy itself. And so you see the relationship of trust between the citizens and their government, the residents of a country and their government, as always entitled to stronger protections, because it goes to the viability of the democracy. Where if you're in China, they have a different model of legitimacy, and one of the things is you don't want to have threats to the stability of the government, which is the first people you go up on are your potential opposition party. Okay, so it's characteristic of democracies that you have strong privacy protections in connection with law enforcement and national security. It's characteristic of authoritarian countries that you don't. And really, one of the first times you tend to see this throughout the world is in the Privacy Act. You also see it in France with the creation of the responses to a similar scandal that took place about the same time. But most democracies have gone through these experiences of recognizing the critical importance of having strong privacy protections in order to maintain the integrity and legitimacy of their democracy.
I disagree with Peter in part. I don't see the Privacy Act really as a Watergate reform. There was a long history of investigations on privacy issues at federal agencies and elsewhere that were held in the 60s and in the 70s. It just so happened that Watergate came along and did provide some opportunity to do something, but there was a long history of congressional concern well before Watergate.
No, Bob, I agree with you in that respect. And if I misspoke and suggested it was just Watergate that did it, that's not my view either. There was a tremendous amount of work done in the 1960s, not simply in Congress, but also throughout, people like Allen Weston, Arthur Miller. A lot of people were writing and raising a lot of very serious concerns in these issues. And those types of concerns were just in the United States. There was an international conversation going on, trying to struggle through these issues. It is, I think we are in a consensus that the 1973 HEW report really did dramatically crystallize a lot of the ideas that people have been working on for over a decade. And you see some of those same ideas in the Fair Credit Reporting Act. You see some of those same ideas in laws in Europe, in Sweden, and in Germany. People were struggling through these issues, but the HEW 1973 report really did crystallize and articulate in a really thoughtful way some of those ideas. And one of the big steps they made was they rejected the idea, at least in connection with these new electronic or computer systems, they rejected the idea of privacy as a right of individual control. And instead, they began to develop privacy around trust models. And in the Fair Information Practices context, that model was based on mutuality, a shared interest in the use of the information. And in other contexts, there's other trust issues that are in play. But they really moved away from this idea that it was a kind of quasi-property right to an idea of trust.
I would add here that if you actually read the HEW report, it's what's really shocking and surprising, and what really hit me is that a lot of the conversations that they were having then, I mean, some of them show age. So for example, there was enormous discussion about the use of the Social Security number and its role. So in this, you know, there was that, but there was something else that really stood out the very first time I ever read through that report. And that's what Willis Ware said. And, you know, for people who don't know Willis Ware, he was an extraordinary man who really understood systems of thinking, systems of knowledge, systems of various kinds of data and information. Excuse me. And there's a quote in the report, and he says, the computer will touch all men everywhere all the time. All right, I'll ignore the all men part, but all people everywhere at all times. He would want that. And, you know, this was a guy who could really see around corners. He was right. And the idea of no secret systems and having a system of records was so that there was risk management of information that the government was compiling. It was really a very early form of risk management.
I just wanted to build on what Pam said, which was so deep, and try to highlight just how important Ware's contribution to this conversation was. You know, Ware was one of the first builders of the first computers back in the 1940s. And, you know, he worked under Johnny von Neumann at Princeton, and his colleagues who were also working with von Neumann there included Claude Shannon, you know, who developed modern information theory, and Alan Turing, you know, who we all know about from, you know, The Imitation Game. And they were moving away from this idea of information as being a thing that individuals control to I mean, what's the definition of a bit that Claude Shannon comes up with? That's the smallest unit of difference that makes a difference in connection with a communicative relationship, so that the essential characteristic of knowledge, of information, is relational. It's not a property or control concept. And you see this right in Shannon's seminal work on communication theory, and where it's all done through math. And you see this in Turing when he starts talking about whether machines can think, you know, coming up with the Turing test. They're moving away from this idea of knowledge as being something individuals own and control in our heads to something that's really a social resource. And I just wanted to say something about one of the other principal authors of the HEW report, David Martin. Martin was the developer before he came into, you know, be the executive director of the committee. Martin was heavily involved in the development of the Cape Cod National Seashore. And that's an ecosystem management system which involves collaborative trust building structures in the management of a social resource, which of course is an ecological resource. The Cape Cod National, you have the fishermen, you have the homeowners, you have the businesses, you have the local governments, you have the tourist industry, you have all these interest stakeholders in a shared common resource. And what Ware and Martin worked out was a recognition that knowledge was a resource that needed to be maintained, and the measure of that sustainability of the resource was social trust. And the fair information practices were a conceptual way of coming up, what are the principles of social trust in connection with relationships of mutuality? And it's so important to see that it's not about control, it's about trust, and how critical, what a huge leap that 1973 HEW report really is.
This is fascinating. I'm seeing active chats and questions coming in, and just for the sake of time, I think I want to turn next to the current implementation of the Privacy Act. And Bob, I think, I don't know if all of our listeners today know, but you published this incredible report in 2021. I know was the product of many years of research and thinking that identifies issues to be resolved with the current implementation of the Privacy Act, and even proposes an entirely revised bill that would update it. For purposes of this conversation, I suggest we set aside the many criticisms around the Privacy Act's exemptions and think about a couple of the main substantive issues that you've identified in this report around defining systems of records, going from traditional kind of retrieval storage mechanisms of 1970s, 80s style databases to some of our current technologies, right? Like how would the Privacy Act apply to something like the purchase or use of not a database, but a system of, say, location data points? Or we're going to talk in just a brief minute about generative AI, right? How does it hold up to emerging technologies like that? And if you like a little bit about compatibility, I find this issue of compatibility really fascinating. And there's also questions for you in the chat. So let me just turn it over to you, Bob, for a second. Like, what are some of the main issues you identified in the report? Has it changed in the last couple of years since you wrote it? Talk to us about that.
Well, one of the reasons I produced this this redraft of the Privacy Act with the help of a bunch of anonymous people was the act really needed to be revised. It's 50 years old. It's only been amended in a serious way once with the Computer Matching Act amendments of 86 or 88, which I was very heavily involved in. And the story is that I went to my boss, the chairman of my subcommittee, in the 80s, and I said to him, I want to spend the next 2 years revising the Privacy Act because that's how long it would take. And he said to me, okay. He said, who's interested in it? And I said, me and the guy at OMB responsible for the act. And he basically said to me, I think you've answered your own question. And the answer was, well, you have something better to do. Nobody pays attention to the Privacy Act. There is legislation floating around all over Capitol Hill. No one is interested in the Privacy Act. So I set out to do what I wanted to do 40 years ago, which was revise the Privacy Act. And there are a lot of things in the act that are troublesome and problematic. Let's pick the compatibility one. A routine use under the act is a disclosure. It's not a use. The terminology has changed over the decades. And how do you control disclosures? And the answer is the Privacy Act says a routine use is a use or disclosure that's compatible with the purpose for which the records were collected. And that's not much of a standard. It's really vague, and it has been abused by agencies constantly over the years. However, if you want to replace that with another standard, it's really hard to come up with something. Nobody around the world has solved the problem of how to set a standard for controlling disclosures. And in the proposal I have, I really didn't do much better. I have some different words, but you have to give agencies some discretion. You have to set up a process by which routine uses disclosures are reviewed, and you have to give the public some say and the opportunity to complain and to go to court if an agency proposes standards that are fail to meet reasonable standards. And that's missing from the Privacy Act today. There's a question in the chat, why hasn't the act created a legal specialty in a body of case law? And the answer is it has to some extent. There are lawyers who do it. Most of the Privacy Act cases, to be honest, are brought by individuals who have been, who think they have been unfairly treated by the federal government, and they try to use the Privacy Act's access and correction rights to reopen some matter that they lost on as a substantive fight. The problem with the act is, other than really being able to fight over getting access to your record, there's no way to challenge what the government does. The government can propose routine uses and establish systems of records that do not meet reasonable standards, and it's impossible for someone to sue, and that's why there's no specialty.
I want to push back a little bit on Bob, because we are obviously in disagreement on this point, that the that in my experience, and I think there are some cases where courts have held that the agency's routine use was not compatible. There aren't many of them, but there are some. And there are also situations, I think, because of the process of going through the administrative, you go to OMB, OMB has to clear it. It goes to Congress. And in theory, Congress could read these things beforehand and push back. And I think the agencies themselves, because typically DOJ doesn't issue, for instance, systems of records notices with new routine uses without going through privacy officers like me, that we tend to be pretty conservative about how much an agency can stretch in terms of what isn't compatible. And there's also another aspect of compatibility that I think is very important. And I think we recognize, you can see this even in what Bob did when he worked on what a new statute would look like. You end up working with a very elastic concept. You're stuck with that because you have the elastic idea of compatibility, or I forget what Bob used, agency, appropriate agency activity. But the idea is that the compatibility has a essentially context-specific characteristic. And so you have to have some way in which that general concept needs to be applied in a specific instance. To some extent, you both want the general ideas of compatibility, but also a sectoral application of those ideas. And that's the struggle of all privacy legislation. It's not simply the Privacy Act. The GDPR, in theory, was supposed to have a compatibility structure through the codes of conduct. They've never embraced that. And the result is that everyone devolves into a kind of seeking consent as a default. But consent if you consent to everything, you're really consenting to nothing, because it just becomes, individual consent becomes a checkbox or a ritual. It's not actually meaningful consent. If you have a strong compatibility concept that's worked out through appropriate sectoral application, then, as in the Privacy Act, when you are engaged or want to make a disclosure of information for something outside of a routine use, you have to get on the phone, find the individual, and get their signed written consent. Now, that's meaningful consent, okay? So the good thing about a compatibility concept, and whatever we call it, and I agree with Bob that there may be better ways of coming up with limiting situations where agencies overreach or overstretch. I haven't actually seen that many instances of it, but when you have a strong concept of compatibility, the default is compatible use, and the exception to the general rule then becomes consent, and consent becomes much more meaningful, much more robust, and much more individually empowering.
So turning it maybe over to you, Pam, in the absence of a case law around this issue of compatibility, I wonder how you think the best approach is for federal agencies to do this, whether they ought to look to the GDPR. I mean, Peter noted all frameworks have some concept of this compatible use principle, but no one seems to have quite figured it out. I'm curious if you could speak to how AI, Gen AI, or just AI generally, training of models, for instance, maybe pushes a little bit more than in the past on this concept.
Yeah.
And also a great question about privacy impact assessments in the
Yeah,
chat.
I'll try to squish it all together. Yes. Okay, so I'm going to start with the issue of various forms of advanced artificial intelligence, and then I'll ooze into impact assessments, of which there are many types now. Okay, so I'll be quick. because of the time. But look, here's the thing. So for people who were at the Privacy Law Scholars Conference, I wrote a paper there that was reviewed by, actually Peter was in the room. And it's a paper that deals with the issue of what on earth do you do when you have data that is fundamentally altered in nature in comparison with our existing approaches to privacy. And the answer is very intriguing. And that's why I kind of hinted at the beginning that privacy is getting ready to change. And I think that's going to be difficult for legislatures and individuals and others to face, but we are going to have to face it. So let me just run down a couple of issues. So let me talk about, for a moment, advanced forms of artificial intelligence. And I'm using that as a very broad bucket of description. But in general, if you think about synthetic content that has been created by artificial intelligence, and there's many ways that this can happen. We all know about large language models, generative forms of AI, et cetera. But in general, just in reference to synthetic content where you're not really sure where it comes from or to whom it might be ascribed, one of the most salient problems that you run up against right away is that the Privacy Act hinges on retrievability. And if you're not sure how you can retrieve a particular record for a particular person with a particular identifier, well, then you're in duck soup, so to speak. You've got a problem. So that's one issue right there. But there's another really, really challenging issue here, which is what I call the collective privacy problem. And this was the topic of the paper that I workshopped at Privacy Law Scholars Conference, which, by the way, is getting very, very close to publication at this point. So collective privacy is really the idea that in our world, in the world that was conceived of, kind of like the flowering of Enlightenment thought, where individuals have rights and, the individual is everything. Well, when you start moving into various forms of artificial intelligence, you move into collective privacy, the world of collective privacy, a lot like the Gattaca court in Rwanda, where you have groups of people who are being handled as a unit. In the Maori tribe in New Zealand, they have a treaty with the government of New Zealand where their privacy is not an individual form of privacy. Their Maori treaty is a collective form of privacy. If in the United States, if you look at the National Institutes of Health, the NIH has a report on the indigenous tribes of the United States in regards to genetic biobanking and the quote unquote All of Us research program, which collects DNA. And the report, which was, I believe it took 2 years for them to write, and they have published it. The report basically states, hey, if you're an individual and you submit your DNA to our project, we cannot guarantee that you will not experience stigma because you will be identified potentially to a group which may have stigma medically. So in the realm of AI and in various forms of advanced, work with AI, you cannot say that groups of people should be excluded from privacy considerations. There are group or collective privacy considerations, and that's the entire topic of that research paper. So are we ready for that? No. Please name me a statute where a group of people or a collective group has a privacy right, other than a very few instances. Now in Alaska, there's some collective actions in the courts and whatnot, and you can find rare instances. There's a movement, the data sovereignty movement in various parts of the world, but in general, this is rare. But when you come to artificial intelligence, this problem of group or collective privacy becomes writ large, because your information might be bundled into many other people's data sets, et cetera, et cetera. You end up with scores upon scores and enfolded information where you become part of a collective group. And good luck finding a statute where your individual right of information removal can be applied. It's just really not possible right now. So this is a very complex problem. This is the kind of problem that I personally like to work on. It makes me happy when I wake up in the morning to figure out, okay, how do we solve this problem? But right now, the Privacy Act is problematic. Now, I saw a question from Hector Dominguez about privacy impact assessments. They're very important. They are one of the most extraordinary methods of accountability for the governments, not just the US government, but they've really spread everywhere. Deidre Mulligan was so pivotal in bringing that kind of idea over to the privacy world from the environmental world. And now we have AI impact assessments with which the UN, UNESCO is really rolling around the world and teaching the entire world basically how to do an AI impact assessment. It's extraordinary. So all of these impact assessments are profoundly important. And I think there's hope there. But our conceptions of privacy, I think, are going to have to shift a little bit, open up a bit more, and we're going to have to start really investigating and interrogating with data, not with theory, just, you know, figuring this out step by step. That's it.
I wanted to just follow on what Pam was suggesting. What are the sort of open questions here? What are the things that we're going to have to struggle with as we go forward into the future? One of the things, Stacey, I want to just push back on something you were suggesting, that the GDPR somehow is a gold standard. I don't actually agree with that at all. And in fact, I think the Privacy Act holds up way better than the GDPR on the whole. And let me just say a couple of reasons why I think that. When the GDPR, the first version of the regulatory impact assessment for the GDPR, before it went over to the Parliament, predicted and noted that the cost of compliance would not be able to be complied with by small and medium-sized industry. And when it went over to the, and so the commission that gets to draft the first draft of legislation in the EU appropriately carved out small and medium-sized industry. And when that bill landed on the Parliament, people said, but this is a fundamental right, so it has to apply to everybody in the same way. So they included small and medium-sized industry. Small and medium-sized industry constitute 90% of all developed economies. That means the GDPR probably has about a 10% compliance rate and can only ever have a 10% compliance rate because small and medium-sized industries can't afford to comply with it. That's something that, I mean, the GDPR type laws make perfectly good sense for large companies that have records management systems. The Privacy Act also works within an environment of the Federal Records Act, where all federal agencies have requirements to have federal record systems. Small and medium-sized industries often don't, usually don't. So to think of the GDPR as somehow this gold standard strikes me as just an extraordinarily idiotic proposition, because how can something be a gold standard if 90% of the people to whom the law applies can never comply with it? That strikes me as I mean, laws like that destroy trust. They don't build trust.
A provocative way to wrap up this discussion. I will not have time at the end of this webinar to fully defend the GDPR, but I will ask Bob and Pam if you want to offer any quick reactions to Peter's comments, and then we've got about 4 minutes left before wrapping up. I'll just ask you all for a closing remark. If you wish, we'll do Peter, Pam, and give Bob the last word on that one. But first, any quick reactions?
Just a super quick reaction. I saw a note in the chat that said, Pam, we were a nation founded on individual rights. Of course we were. My point is that we're moving into a new era. The individual rights don't go away, but we do need to start thinking about how AI is changing privacy. It's very complex, and it's going to be very interesting. In terms of what Peter's talking about, I have mixed feelings about the GDPR. Look, the GDPR has been very important. If you look, WPF, World Privacy Forum, did a very large piece of research that took 4 years to do. We looked at all the data governance in all the countries of the world, big and small. And the GDPR is in 166 countries. I think that's overall a good thing. I think it's a benefit, and I think it's allowed baselines to emerge. Now, I do think we need to build on those baselines, and I do think that the GDPR is very, very difficult for the global majority countries. Sometimes the economic infrastructure does not support some of the bureaucracy that GDPR requires. So I think there are significant challenges depending on what jurisdiction you're in.
Well, let me say that I don't really totally agree with what Peter said. I think the GDPR has become the gold standard. It has not been adopted in all of the countries around the world as sort of the basis for their privacy laws because it's a failure. And I think Peter does have some points that I do agree with, but I think that the GDPR, I would not characterize it in the same way. And I also think, for what it's worth, that the Privacy Act itself has a lot of good points, but it also has a lot of shortcomings where the federal government, with a lot of resources, the agencies don't keep up to date, and a lot of their publications and activities relevant to the Privacy Act are not current.
Amazing. I think we will close it out there, folks. It's rare to get people who are such incredible experts on this niche topic who are also willing to disagree with each other and get into it. So this is just such a pleasure for me. I do see we had a couple of questions in the chat that we didn't get to. I'll circulate them around with the speakers afterwards and see if I can get back to you. We also had a question about the recording, and the answer is we don't know yet, but we'll circulate it if we can. If not, you'll have to tell your friends that you were here and we're able to participate live. Yeah, so with that, I'll just say thank you so much to our speakers, Peter, Bob, Pam. You're incredible. Thank you all so much, and thank you to everyone who joined us here today. Have a good rest of
your
afternoon. Thank you, Stacy, so much. Take care, everyone.